I believe I have April D. Bell on this meeting as well.
Yes.
All right. Participating by audio only at this point. And then apparently there's a Brent Bell and a Brandon Bell also participating.
Yes, this is
Uh,
Brent.
Okay.
Sorry, that's correct. I'm Brandon.
Okay. This matter was to come before the court for approval of the petition, which requested that April D. Bell be named executor and be given letters testamentary. Apparently, the primary executor under this will was Sharon Bell, but she predeceased the decedent. Mr. Hargrove, you filed this petition asking that April be named as executor. Is that still your position? That she?
It is, Your Honor, and uh, just as the court may or may not know, Sharon Bell, who was the spouse at the time of the execution of the will, uh, passed away. Mr. Bell then remarried, so we have a surviving spouse involved in this, Latoya Bell Evanson. She has sought counsel really at my request and is being represented by Susie Locke. Susie
Is there a
Locke.
reason why Susie isn't participating this morning?
No, Your Honor, she did send me an email, and which was dated the 20th, which basically says we do not intend to challenge the petition and appointment in the Keith Bell estate. I do not plan to appear at the hearing, but can do so if necessary. She then plans and says we will be filing an elective share petition once the probate is opened.
All right.
So that's the position of the surviving spouse, and they've been married for 17 or 18 years, so it's been a long term marriage.
All right. Brandon, I'll address you first. Are you opposing the appointment of April Bell as executor of this estate?
Your Honor, I'm not opposing. I think there was um, uh, there was some confusion early on, and I think I can't really speak on my brother's behalf, but I think there was some um, conflict over items in the will and how they would be carried out, and so that I think that led to some conflict and why the letters of testament were not all signed. We have there's a fourth heir who's not present, our brother Brad Bell. Um, he has some mental health issues, and um, unfortunately, was not able to be here. And so I think that assuming these issues can be resolved, I think we can move forward. I think there's an issue that there's several complications in the will, and I think one of the primary things that's possibly holding things up is the one of the Colorado properties. Well, actually, two of the Colorado properties, and in the will there is a section for that the executor can appoint somebody to live in one of the properties rent free. And so my sister is now living in the house that my father had in Boulder, and wishes to continue that. And I think that came up as a subject of contention. And so I think if we can resolve that point, I would hope that this can all move forward. But at this point, I don't. Um, I I'm hoping we can all come to a mutual understanding and be able to move forward.
All right. Thank you, Brandon. Brent Bell, are you opposing the appointment of April Bell as executor of this estate?
I'm as of now, yes, I would oppose it based on what Brandon just said. It's really this simple. The estate, I think Jim has a little undervalued on his sheet. He's listing it, I think it's 3 million in his petition. It's really probably going to be around 5. You can look on Zillow and the property that Brandon's referring to, and where my sister's listing is her primary address, which is actually my dad's address. That's an estate property, is going to be worth somewhere around 1.6 million. That being the case, if you read the will, that each beneficiary is to receive 1/4 after expenses, then you could take, that's a simple equation. It's 5, if X is the expenses for Jim's fees, taxes, and whatnot, it's just 5 million minus X divided by 4. And that's going to be more than or going to be less than 1.6. So April needs to either sell the property or buy the property, and she's been resistant to doing either. And Breckenridge is kind of a wild card. My dad told me that he had received 7-figure offers on it and that was probably 5 years ago. That could be worth possibly as much as the other house, in which case the same thing applies. When I've asked about selling the Breckenridge property, my sister will do no more than commit to not developing it. She's been very non-committal about actually putting the thing on the market and liquidating the real estate. Therein lies the issue. We've been trying to resolve. The reason I guess I'm a little more adamant in my position than Brandon at this point is that we've been trying to resolve this since August 10th, when my dad passed away. April's saying she's got $100,000 of her own money into that house, and she's using a letter that Dad wrote to justify her continued occupancy. In that same letter, it states that for major expenses, she would be reimbursed for repairs on that house, and I would consider $100,000 to be a major expense. And if she was not compensated for that, then I don't see that as being the other beneficiary's problem. And I don't know that an executor can have a claim on the estate from what I've read. So that, and then lastly, there's this matter of some ranch properties, and I can name them.
Okay, well, Brent, I think we're going way beyond the scope of what the initial hearing's all about.
Okay.
You're getting into construction of the will and perhaps some disputed issues regarding resolution of the property, which certainly may be legitimate issues, but the initial process is to get a fiduciary, in other words, an executor named to start managing this estate. And that's the stage that we're currently at. The court's not going to enter any final orders today regarding disposition of property, who's going to get what, or even construction of the will. The only issue that I would have for Mr. Hargrove is it would appear that there's at least some potential that your client may have a conflict of interest with the estate itself. She apparently is making an assertion of some claims regarding entitlement to property or entitlement to possession of property, which may be adverse to the position of the heirs as a whole. Your position on that?
Yes, Your Honor. And again, the will, which Mr. Bell prepared many years ago, has his paragraph Article 9, which specifically addresses exactly Brent Bell's issue about the personal representative that may be living in that house. Other family members, as the Bell brothers know, lived in that house for many years before April had lived in that house. But again, Judge, that is an issue that can be taken up in the probate. I mean, we've got a substantial estate. Probably the numbers that I put in that petition, as estimated value, and that's just what those are estimated values. But we're sitting there with some substantial properties, got some tax issues coming up. We have these things, plus the elephant in the room is this situation with a spousal allowance. I mean, as Brent Bell says, well, it's just going to be a split between us. I think that's totally wrong. I mean, there's going to have to be serious negotiations with a 17-year-old, or a marriage of 17 or 18 years. And so that's the game changer in this matter. But again, I have again from either of the Bells, and in fact, Brandon Bell has signed the waiver to get the will admitted to probate. But Brent Bell, as the court well knows, I mean, the issues to try to either keep this will from being put in place or to contest the executor is, was he competent when he made that will more than 20 years ago? Certainly he was. He was a successful businessman for many years after that. Did April somehow exert undue influence on him back there 23 years ago? No proof of that. But the other matter, and it is peripheral in a way, but Keith Bell, this year, July 11 of this year, did a new general durable power of attorney, which was executed, was prepared by our office, naming April as his primary power of attorney, with Brandon being the alternate. So, 4 months before he died, April Bell was the person clearly that was going to be handling his affairs.
May I interject one point? I will not oppose this appointment. That's really not my point. If you're using my equation as 5 million minus X divided by 4, what you've just alluded to in your last remarks was that X is a different number. So X is bigger. It's still 5 million minus X divided by 4, correct? And don't you agree that that's greater than 1.6?
Well, Mr. Bell, and I certainly do not want to argue with you, but let's say it's an $8 million estate. Let's use that number. Let's say that surviving spouse gets half. Then you've got $4 million you're dividing 4 ways. And that's the number we don't know. That's the number that I am very confident we can work a mediation with the wife, the spouse, and her son. But that's the number that we don't know now. April and the surviving spouse, who goes by the name of Tiny, have a very good relationship. This is a woman I know very well. I know her son very well. I mean, I am hopeful we can get something done. But Your Honor, and I think that Mr. Bell probably does know, but our law firm certainly doesn't operate in a vacuum. I mean, before there would be any sale of any of the property or anything, we're going to be contacting you folks. I mean, it's not that you're going to be involved after the fact on this thing. That's not the way that we've operated, and we've done this for many years and in contested ones. But Brent, I don't want this to be a contested thing. I want us all to be moving toward getting this estate liquidated and getting the monies to you all, and the share that Brad gets to be held in a trust for him.
Well,
that's our plan.
I do too. I'm not disagreeing with you. I don't really care who executor is, and it doesn't sound like a job I'd want. But the bottom line is she has no intention of moving.
Well, again, I mean, I think that will be down the line. I mean, the properties in this estate are, will end up getting liquidated on doing that, and whether there's an election to have that set off against her share, I do not know.
And I do think that that's, most of what has been said so far is a misrepresentation of our previous conversations and attempts to be more collaborative going into this. There was discussions about, yes, having to sell Breckenridge and how sad that was because that was my dad's dream. But we all, I think, understand that that probably has to happen. And there was also an attempt on my part to negotiate a number of years, just a lease so that I have time to move. And so, I don't think what's been stated so far is an accurate representation of that conversation.
All right, and there's obviously issues that have to be sorted out in this estate, which are not currently before the court. I do understand Brandon and Brent's concerns about how this will is going to eventually be construed and how assets are eventually going to be appropriated, but that is yet to take place. The court does not deem at this time that the named executor under the will should be disqualified, and the court will approve her as executor of the estate. April D. Bell is appointed as the executor of this estate. Is bond waived in this will, Mr. Hargrove?
Sir, that is a good question that I apologize for not having an exact answer on that. I just am so used to seeing the waiver of the bond there. Let me see here. Yes. In Article 8, the powers of personal representative on that is at the end of that speaks of the fact that there's not going to need to be a bond. And in fact, the same language as we have to be able to carry out without court orders. The same language under our probate code, the same language that we have.
Where do you see waiver of bond in here?
Hold on here. Let me look. What? Okay. What it does, and this is again, I think, Your Honor, very much the same language that we have in our wills here in Kansas, that without the necessity of a court order on doing that. And so I'm saying that there is no requisite for the estate having to go to the substantial expense. And then as the court realizes, I mean, the bonding companies on a $7 or $8 million estate, I mean, that is a very substantial bond. I mean, I don't think that either Mr. Brent or Mr. Brandon have a concern. I don't believe that somehow that April's going to run off with the land.
Right.
The land
understood.
is
and in Article 5, Mr. Hargrove, it is addressed. The successor or substitute personal representative who shall also serve without bond shall be April D. Bell.
Thank you, Judge.
The will directs it.
Yes.
Bond will be waived. However, under the circumstances, I believe that the other beneficiaries of this state have some reason for concern that they've expressed. And I'm going to overrule any provision in the will that might be construed to allow her to lease, borrow against, or sell any of the real estate without court approval. I'm not saying that I won't agree with her decisions. However, that I want that the other beneficiaries have to receive advance notice and it needs to be set for hearing. And then I'll make an appropriate ruling on any lease, borrowing against, or sale of real estate involved in this estate.
Okay. Your Honor, let me suggest this. We have sent over an order. Let us amend that really from being unsupervised to supervised. Then that's going to take care of all of your concerns on doing that.
All right. I haven't seen your proposed order, I don't think. So if you'll go ahead and get that over to me today, Mr. Hargrove, that would probably be better. Can you do that?
Yeah, yes, sir. Yeah, we can have it over there by 11.
All right. I will try to address that. There'll be an order appointing. Has her oath already been filed of record?
No, we have it right here.
Okay, well,
no, we have it right here. We've got the whole packet of papers that we'll get over.
And then I would intend to address the order and the letters testamentary today. So Brandon and Brent, the way that we've left it is if she intends to do anything with any of the real estate, it has to be noticed up to you first. And then it'll need court approval before it can go through, before she can carry out any plans that she has. That's not necessarily meant to be some casting an aspersion about her ability to make a good business decision, but I think I want everything to be totally transparent. And I want to make sure that you have an opportunity for input if you feel like something is amiss in some way.
I think that's fair from my standpoint. Jim did mention that they would be liquidated, and if that's the case, I'm fine with it.
All right. And then Susie Alaka presumably will be filing some paperwork in the near future, I trust, Mr. Hargrove?
That I anticipate that, and when we get that, whether or not she notices up Brent and Brandon and Brad, gents, we will send you copies of whatever she files, because that's going to be the main concern about the value of the estate is going to be tied into what Tiny gets.
What is Brad's capacity currently? Does he have a guardian or a conservator appointed for him? Is there?
Your Honor, he does not. I believe that he should have one. He has currently he's living in it's a state assistant facility for people who have substance abuse issues. Yeah, currently does not have any representation. I do have frequent contact with him, but he's not under guardianship.
Your Honor, in the will, and this is even back in 23 years ago, there was a specific paragraph regarding the distribution to Brad. I mean, this has been an ongoing deal, and basically, what they're looking at is setting up some type of a special needs trust for handling his money. But gentlemen, how old is he now?
He was born
58.
in
58.
So
how old?
58.
Oh, okay. Because those special needs trusts work up till the age of 65, but that's something that we will all have to get together to try to work on, to be able to shelter his dollars, because I imagine that the state, the feds, or somebody has probably already got a pretty good debt setting there that they'd be looking to try to get, but that's not insurmountable.
Well, I'll also note that this trust appeared to be a stopgap to manage assets until both of the husband and wife team passed away.
Right.
So whether the trust contains provisions for Brad may not apply to distribution under the will.
Right. And it may be a situation that some family member may really have to be looking at trying to get involved in a guardian and conservatorship for Brad, which may be a load that no one wants to take on. I don't know those circumstances to be able to try to get his assets over into a conservatorship for him.
Okay, where does Brad live?
Or Brad?
Brad.
He's currently living in Denver.
Okay, that'd be a Colorado matter.
Yeah.
But in this case, I guess I'm just questioning, does he have capacity to, say, sign off on a settlement agreement or to be contacted and give some sort of verbal okay? Does he have the capacity currently to do so? If he doesn't, then the court needs to consider appointing a guardian ad litem, in this case, an attorney who can scrutinize matters and act on his behalf. Now, again, that is an expense for the estate, and I don't take it lightly, but I just don't know the status of Brad's mental state and whether he has the capacity to be acting on his own.
Your Honor, we have been in contact with a law firm in Colorado because of what I anticipate to be the ancillary probate on the Colorado property. And I may talk to them about getting involved in a guardian ad litem role for Brad. Gentlemen, or
I couldn't appoint a Colorado attorney.
No,
to be a guardian ad litem in a Kansas case.
I misspoke about maybe even trying to go ahead on a guardianship or something. I mean, I think that's where we will end up having to have a disinterested third party sitting there in a guardianship role.
Conservatorship. So somebody to manage the money that he would eventually get from this estate. So frankly, he doesn't blow it.
Yeah. Yes, we have to do that at a minimum. As far as making a decision now on things, I don't think that he would be capable of, but I don't know, Brandon would.
I would agree with that. I think he would benefit greatly from either legal representation or a guardianship.
Yeah,
I'd agree with you.
Well, Mr. Hargrove, there seems to be a consensus that maybe there's something you maybe could talk to the Colorado firm about. Obviously, establishment of a conservatorship would have to be done under Colorado laws and Colorado rules, and it would probably be a Colorado-based conservator, as long as it's someone responsible who's going to make sure that his matters are taken care of. That's really all we're interested in. So if you'll go ahead and pursue that, I'll hold off on appointing a guardian ad litem, but this time, pending on further report from you as to what you found out.
We'll do it, Judge. And Brandon and Brent, thank you very much for your courtesy and cooperation. I mean, this is a mutual effort that we're going to pull through. April will do a good job for you. I know you know that she will do that.
All right.
Thank you, Judge.
All right. I'll look forward to receiving the paperwork later this morning. Gentlemen, have a Merry Christmas.
You do the same. Thank you.
Thank you.
Thank you.
There's nothing further at this time. This